Hey y'all, Gary here with Tennessee Stands. All right, so have had a chance to sit down and look through these two Supreme Court rulings regarding the OSHA mandate and the CMS mandate. Of course, many of you, not all of you, know by now that the OSHA mandate was stayed by a 6-3 decision by the Supreme Court, but the CMS mandate concerning healthcare workers was not stayed. That was a 5-4 decision. With three of our champions that I told you about, and you'll see this in this opinion here in just a minute. You've got Thomas, Alito, and Gorsuch. Those three, Thomas, Alito, and Gorsuch, just like I said in my last video from listening to the arguments that happened in the Supreme Court, they're on our side. They're on the side of liberty. They're the only three justices really talking about the Constitution, even mention the 10th Amendment. And you'll see some of that in their opinions coming up. But warning, this is going to be a little bit long. So if you're not into really sitting down and digging in, you might want to move on. But I hope you don't do that, because what is in these opinions? Hear me. You have to understand this is more than just about whether or not the OSHA rule or the CMS rule was stayed, which gives you, like I said, only a temporary reprieve. Understand that the court's stay on the OSHA rule is temporary, and what I mean by that is it's not that it's set to expire. My point in using the word temporary is that this is not the final decision of the court. They still need to render a final decision on the case itself. The stay simply means that they're not going to allow the mandates to continue to go forward while they are now still deliberating over what their final ruling is going to be. Because they issued the stay, most likely they're going to rule in our favor. So you can probably expect that. But what the reasons they gave, and that's why we read these opinions, because it's not just the result. You have to understand what's been happening up until now and how the courts see it, because that's going to give you insight into what's coming. And so the idea that everything's good in Tennessee, we don't have to worry about it, wrong. We always have to worry about it. And the not worrying about it, which some of you unfortunately are already there, is how we got here in the first place. All right? So let me push ahead. I'm gonna start going through, point out some things that we need to pay attention to. All right, so this is the ruling. This is the OSHA ruling from the Supreme Court that was issued just yesterday on January 13th. And some key statements here that I want to point out. Of course, you know that this OSHA rule was an emergency temporary standard, so it wasn't a regular OSHA rule. But some things that these justices did point out was this. The secretary, the law says, per the OSHA Act, that the Secretary of Labor must show, one, that employees are exposed to grave danger from exposure to substances or agents determined to be toxic or physically harmful, or from new hazards. Now look, you can pretend that all of those words means a virus. But for any reasonable person, words mean what they mean. And unless you want to make them mean something else, the idea of new hazards and toxic chemicals and substances to be physically harmful, look, we know that they're talking about workplace hazards. They're not talking about health hazards, viruses or contagions or communicable diseases. OSHA has overplayed its hand and overextended its authority. It's never been given the authority, and you'll hear that later on from the judges. And interesting from the justices. And interesting, they've been challenged before. Before COVID, ETS rules such as this have been issued 9 times. And of those 9 emergency rules, 6 were challenged in court, and only 1 of those challenges was upheld. So, point is, they've tried to do this before. They're going to continue to try to do this, and they've not been very successful. Tyrants be tyranting, okay? So that's a good point to make. What's some key things I want to point out? The only place you'll find in this curiam opinion, which is the majority opinion of the court, they mention that the Fifth Circuit raised the issue of separation of powers. You'll never, that's a constitutional principle, obviously, separation of powers. You won't hear the Constitution talked about again in this opinion until you get to Justice Thomas's opinion, Justice Gorsuch's opinion, and that's unfortunate. Right here, here's some things I want to point out. I made some notes. Here's what the court says. Administrative agencies are creatures of statute. They accordingly possess only the authority that Congress has provided. That's a true statement, but here's my concern with what they didn't say. Their only concern seems to be that there was not a clear authority given by Congress to OSHA, but they're not asking the question, what would the Constitution give Congress the authority to delegate this kind of power? Where is the power for the federal government to issue sweeping health care requirements found in the Constitution? This is a 10th Amendment issue and should therefore be reserved to the states. And you'll see what I'm saying here later on in this opinion. They're proving the fact that they're not entirely sure that the federal government doesn't have this power. All they're saying is that they don't see that Congress necessarily has given OSHA this power. But if Congress had given them the power, well, then they can issue the vaccine mandate. So careful. Keep paying attention. They say the act, this is the OSHA Act, the 1970 OSHA Act that created OSHA. The act empowers the secretary to set workplace safety standards, not broad public health measures. Agreed. COVID-19 can and does not spread at home in schools. Can and does spread at home in schools, during sporting events, and everywhere else that people gather. That kind of universal risk is no different from the day-to-day dangers that all face from crime, air pollution, or any number of communicable diseases. So, what they're saying here is, look, OSHA only regulates the workplace. By making this vaccine mandate, they're trying to regulate everything, and we can't allow them to do that. So I appreciate that, but here is the scary part of the opinion. This is the part, if you hear nothing else in this video, this is your takeaway. Here's what the justices had to say. That is not to say OSHA lacks authority to regulate occupation-specific risks related to COVID-19. So too could OSHA regulate risks associated with working in particularly crowded or cramped environments. It's probably one of the most concerning statements in this opinion and drives the point home that they are not convinced that the federal government does not possess this kind of extraordinary power. They are leaving the door open for OSHA to try again. Their primary concern was that this regulation was too broad and affected over 84 million Americans. Perhaps if the rule was more tailored and only impacted, say, 10 million Americans, then perhaps it would be okay. How is this kind of reasoning even considered when having a constitutional argument? Either they have the authority or they don't. And that's my concern, and that should be all of our concerns with what we're not hearing the court say. What we're not hearing the court say is, hang on a minute. The federal government does not have, per the Constitution of the United States, has not been given this kind of power over the everyday lives of individual Americans across the country. Federal government just doesn't have it. What they're saying is, well, we're gonna issue a stay on this OSHA rule because we feel like, first off, well, Congress didn't necessarily give them this specific power, so we don't like that. We also don't like that the OSHA rule was so broad, and it affected 84 million Americans. It was just too broad. But maybe if you know it was just, if it didn't affect so many Americans, if there were only specific circumstances where OSHA mandated that Americans have the vaccine, then maybe we'd be okay with it. That's scary. That's scary coming from the Supreme Court. Let's keep going. Here's another one. The lack of historical precedent, coupled with the breadth of authority that the Secretary now claims, is a telling indication that the mandate extends beyond the agency's legitimate reach. Agreed. However, the lack of historical precedent, if there was any precedent for this having been done in the past, it would still have been wrong in the past, and someone should have shut it down. These courts always look to, well, has this happened before? Because if it's happened before, well, then maybe it's okay. It doesn't matter if this has happened before. It doesn't matter if OSHA or the FDA or the EPA or the SEC or the name your three-digit agency. Who cares if they've tried to do this? The question is, look at the Constitution. Do they have the authority to do it? No, it's not there. Then shut it down. We don't care if they've tried. They'll probably try again. The closing statement on this, they say, it is not our role to weigh such trade-offs. In our system of government, that is the responsibility of those chosen by the people through the democratic process. So they're saying, look, really, this shouldn't even be in the court. OSHA's overstepping their boundaries, and Congress needs to fix it, and this is really Congress's role. And I agree. I appreciate the fact they're saying that. But now here's before we leave the OSHA opinion, here's what I want to take you to. This is where there's actually some good stuff. These statements are going to give you a little bit of hope. So what I just read to you was the court's majority opinion, which I can only, it's a curiam opinion, so they didn't say who wrote it. I'm assuming Chief Justice Roberts wrote it. And I'm also assuming that Kavanaugh and Barrett agree with the opinion, because Justice Gorsuch wrote a concurring opinion, and Thomas and Alito joined in concurring, and Kavanaugh and Barrett did not. So again, like I stated before, you've got Gorsuch, Thomas, and Alito. Those are our three in the Supreme Court that's holding the line of what is constitutional. And I love the opening statement of their opinion, because they get it. They say the central question we face today is who decides. That's it. It's not about how dangerous is this? Do vaccines work? Should we do this? How do we protect people? No. The question is who decides? Who has the authority? Does the Constitution give the federal government this kind of authority over Americans? That's it. That's the question. So I really appreciate that. What a great opening statement. Here's what they say. There's no question that the state and local authorities possess considerable power to regulate public health. They enjoy the general power of governing, including all sovereign powers envisioned by the Constitution and not specifically vested in the federal government. Finally, we've got justices that are having the right conversation. We're talking about the 10th Amendment, what's reserved to the states. But I want to point something out. Super important. It's important to point out that from a federal perspective, this statement is accurate. However, understand that a state's ability to regulate public health would still be subject to its own state constitution. It's crucial you get that, because you'll hear a lot of people that will say here in Tennessee, well, the state has a right to mandate this and the state has a right to mandate that because of the 10th Amendment, and the federal court said we could. Well, yeah, that's great that the federal court is acknowledging that states have reserved powers. That's awesome. But we also need to recognize here in our own state in Tennessee that when our legislature or our governor or our courts are working to govern us, that they also still operate under the idea of the consent of the governed. Everything they do, every law our state legislature makes, our General Assembly, is still subject to our state constitution. So while the federal government may say, yeah, Tennessee, you have police powers, you can make health mandates, okay? We have to go look at our Tennessee Constitution and say, okay, well, how far can the state really go? All right, so the state constitution is always still a limiting factor in the way government operates and enacts policy over our lives here in Tennessee. That's just important to point out. They say, I love this. It seems, too, that the agency pursued its regulatory initiative only as a legislative workaround. Keep in mind that during this whole time, there have been bills presented to Congress to make a vaccine mandate in the United States, to just make a vaccine mandate. Congress has, the Senate flat out rejected the vaccine mandate. They voted it down in the Senate. So Congress has refused to act. Thankfully, I think they realize, hang on a minute, we don't have the power to do this. The court's recognizing that what happened is Congress wouldn't do it. So Joe Biden, by executive order, was trying to use an executive agency to do a job that Congress refused to do. And the court sees it. I'm thankful they said it. Thank you, Justice Neil Gorsuch, for speaking the truth. So they bring up the major questions doctrine. Essentially, if administrative agencies seek to regulate the daily lives and liberties of millions of Americans, the doctrine says they must at least be able to trace that power to a clear grant of authority from Congress. This is also sometimes called the non-delegation doctrine. And here's what they say here. The non-delegation doctrine ensures democratic accountability by preventing Congress from intentionally delegating its legislative powers to unelected officials. This is a huge statement. Listen to what they're saying. They're expressing concern about powers supposedly given to the administrative state, where people are ruled by unelected bureaucrats with little to no accountability from the people over which they rule. You know, this concurring opinion is big, because we're going to have to hang our hat on this, I guarantee you, at some point in the future, as these administrative agencies continue to assert powers and seek power that they don't really have. The justices here, in their opinion, are recognizing we need to watch out. We need to just hold the phone a minute. We need to recognize that if we allow agencies to operate in this way, that they'll continue to seek powers for which they are unaccountable to. Why? Because they're unelected. It's a crucial point. Their closing statement. The question before us is not how to respond to the pandemic, but who holds the power to do so. The answer is clear. Under the law as it stands today, that power rests with the states and Congress, not OSHA. But if this court were to abide by them only in more tranquil conditions, declarations of emergencies would never end, and the liberties of our Constitution's separation of powers seeks to preserve would amount to little. These three justices, Gorsuch, Alito, and Thomas, recognize how dangerous this is. And they're warning us. They're saying if we don't stop this now, if we don't put the nail in the coffin, if we continue to allow the powers of these administrative agencies, these unaccountable, unelected agencies, to continue to expand without authority expressly given to them by Congress. And what you should add to that is it constitutional? So I'll leave that there. But look, we're going to get to the CMS rule. I told you this video was going to be long. We're about, almost 20 minutes in. That's the OSHA ruling. We're going to get into CMS in a minute, which is not awesome. But it's important to note, if you're in Tennessee, I want to say this succinctly before we move on to CMS. If you live in Tennessee, if you work in Tennessee, if you are a permanent resident of Tennessee, and you work for a company in Tennessee, or you work for a company based outside of Tennessee, if you are a full-time employee or a part-time employee, if you are employed and you're a full-time resident of Tennessee, it is illegal in the state of Tennessee per Title 14 and with the stay placed on this OSHA rule for you to be discriminated against based on your vaccination status for COVID-19. And your employer cannot and shall not take any adverse action against you because of your vaccination status. They cannot treat you differently. They cannot make only unvaccinated employees pay more for health insurance, wear masks, take tests. None of it. So understand that. Stand your ground where you are. These are the rights that you now have as citizens of the state of Tennessee. Let me correct that. These are rights that you have always had in the state of Tennessee. All right. A couple of things I want to point out on the CMS ruling for those in the healthcare industry that are still dealing with these mandates now under this federal overreach. You need to understand the court recognizes, I repeat, to every hospital, every healthcare provider who is employing healthcare workers in the state of Tennessee, please hear this. The Supreme Court of the United States recognizes that you need to allow for medical exemptions and religious exemptions to this CMS mandate. I know some of you are pushing back against me saying this. I push back against me saying this sometimes. We should all not comply. No one needs exemptions. You should not be forced to have these shots. I'm just saying from a practical perspective, people are stuck. You're stuck in between courts, legislatures who refuse to take action, courts who refuse to defend you, and employers who continue to enforce unconstitutional edicts from the federal government. All that considered, I just want to hit the point home. The Supreme Court recognizes that you have a federally secured, a constitutionally secured right to medical exemptions and religious exemptions to this vaccine mandate, and you need to use them right now. All right. Let's look at this. All right. The rule requires providers to offer medical and religious exemptions and does not cover staff who telework full-time. Another important point, okay? The rule states if you work 100% from home and you don't go into the office, a healthcare provider cannot fire you based on proof of vaccination status. Important point to get. Here's the misinformation that the Supreme Court is operating on. Here's where things get a little crappy. In many facilities, 35% or more staff remain unvaccinated, and those staff, the Secretary explained, pose a serious threat to health and to the health and safety of patients. This argument is based on the myth that the vaccine is going to save us. See, they're concerned about risk. Where are they getting this information? So the Supreme Court is quoting all of this risk that the CMS agency says that we're under, and this is what they're basing their decision on. This is what's crazy. The Secretary also found that fear of exposure to the virus, listen to this, fear of exposure to the virus from unvaccinated healthcare staff can lead patients to themselves forgo seeking medically necessary care, creating a further risk to patient and health and safety. So now it's said that patients who need medical attention are scared of the unvaccinated patients and workers who may put them at risk. They're concerned about fear. Court, we need to act. You need to let us make this vaccine mandate, because if we don't mandate these vaccines in our hospitals, well, people who really need medical treatment, they're going to be scared to come. No, let me tell you what's actually happening. I can tell you of cases right now at Vanderbilt Hospital in Nashville, Tennessee. People want to go to the hospital because they need a kidney transplant. Like, they need it now. And they don't care who's vaccinated. They want the treatment. They ain't scared. Vanderbilt is refusing to treat them because they are unvaccinated. So, correction, Supreme Court, for all of the misinformation that you're being fed and the lies that you're believing. Patients aren't scared of the unvaccinated. Hospitals are turning away the unvaccinated and refusing to give them life-saving medical treatment. That's a crying shame, and you had a duty to protect Americans from that egregious discrimination, and you failed to do so. Shame on you. Let's keep going. The Secretary of Health and Human Services determined that a COVID-19 vaccine mandate will substantially reduce the likelihood that healthcare workers will contract the virus and transmit it to their patients. Based on what? SCOTUS is making a decision on completely false information that the vaccine prevents transmission. What are we talking about? Who is saying this? Who is literally still saying today that the vaccine prevents the transmission of COVID-19? This is the information that the Supreme Court is determined to base its decision on. Let's keep going. Vaccination requirements are a common feature of the provision of healthcare in America. Healthcare workers around the country are ordinarily required to be vaccinated for diseases such as hepatitis B, influenza, and measles, mumps, and rubella. See, here's the problem. We've accepted tyranny for too long. You understand that, right? We've accepted tyranny for too long. Again, historical practice is at play. We've required the flu shot, so why not a shot for COVID? Which begs the question, do you think that requirements for flu shots, listen to me. Do you think that requirements for flu shots have always just been about the flu? Or maybe through all the years that we've been required and pushed to get flu shots, could it have been about something else entirely? I think so. Let's keep going. What else do I have to say? Let me just go to their closing statement here. The challenges posed by a global pandemic do not allow a federal agency to exercise power that Congress has not conferred upon it. Agreed. Thank you. However, here's what else they have to say. At the same time, such unprecedented circumstances provide no grounds for limiting the exercise of authorities the agency has long been recognized to have. And this is the problem. Even if you would expect, how do I want to say this? If there was any branch of government, any body, any agency that you would hope that would make a judgment based purely on liberty, the Constitution, and the rule of law, you would hope it would be the Supreme Court of the United States. But even the Supreme Court is saying, we recognize there needs to be statutory authority. But when times are unprecedented, when things are just really dangerous, this is dangerous speak coming from our federal government. All right, let's close with one more. So Justice Thomas offered the dissenting opinion and basically giving his reasons why he felt like the CMS rule should have also been stayed. For time's sake, let me go down to the meat and potatoes. There was one thing I wanted to point out here. Check this out. All right. The only way that CMS found that it could even pretend that it had this authority was to incredibly stretch the language of the authority it's been given by Congress. And listen to Justice Thomas points this out. The language says it regulates, Medicare and Medicaid can regulate long-term health care facilities and mandates an infection control program among its health and safety provisions. But that infection control program focuses on sanitizing the facility's environment, not its personnel. The defense for CMS, whenever they argued before the Supreme Court, said, look, we can make this vaccine mandate, this federal mandate, because Congress has authorized this in long-term health care facilities to provide for infection control. So they took that to mean they can mandate vaccines. And what Thomas is saying, wait a minute, hold the phone. Not only does infection control not mean you can mandate vaccines, but Congress went on to explain what it meant by infection control. And it talked about sanitizing environments, cleaning it up, not sanitizing someone's body with a vaccine. Words matter. Words matter. And we just don't seem to care. We don't care about the law. We just do whatever we want to do anyway. His closing statement. Another important thing Justice Thomas points out. Again, 10th Amendment. Vaccine mandates also fall squarely within a state's police power. And he closes with this. These cases are not about, this is what the Supreme Court needs to understand, what you need to understand, what our legislature needs to understand. God help us. These cases are not about the efficacy or importance of COVID-19 vaccines. They are only about whether CMS has the statutory authority to force healthcare workers by coercing their employers to undergo a medical procedure they do not want and cannot undo. Do they have the authority? The answer is no, they do not. So let me just close with this. Here's the thing. In special session, the most egregious thing I heard from legislators in terms of putting in these exceptions, because our Tennessee law made an exception for federal contractors and made an exception for CMS, if the federal government was going to mandate, and we begged them not to. If you watched our videos, you remember all that nonsense. And what I heard from legislators was, well, look, we've got to pass this law, okay? We know there might be some challenges, but Gary, we got to leave it up to the courts. We're not sure if what we're going to pass, we're not sure if we place those restrictions on employers. We don't know if it's constitutional. So we're going to have to leave it up to the courts. No, you don't leave lawmaking up to the courts. Why? Because as you're reading through these opinions, you understand really quickly how even 6 conservative Supreme Court justices are conflicted themselves about what liberty is, about what the 10th Amendment is, about whether or not Congress can define by statute anything that a federal agency can do, or whether or not it's limited by what it can authorize someone to do by the Constitution, or whether or not maybe the federal government has no place in this at all and it's reserved to the people or to the states. My point is, if lawmakers across the country in every state, not just in Tennessee, because let's be honest, Tennessee is one of the only states, I think one of only 2 states right now, that has passed any law that makes it discriminatory for an employer to discriminate based on their vaccination status for COVID-19. So look, kudos to our Tennessee legislature for at least doing that. That we did something here in Tennessee, okay? But the bigger issue is that if we continue to pass laws that as we pass them, we defer the rest of our lawmaking to the court. If our position is we're going to make this law, but at the end of the day, we really need to know what the court says. Y'all, we're in trouble. We're in big trouble because the courts rarely in 2022 see it like you and I do. And so this isn't just pushing back against federal overreach. Hear me, and I'll close with this. This is pushing our legislature. It's time to push our governor and our legislature beyond their level of comfort to passing laws that directly fly in the face of the Supreme Court and dare the Supreme Court to obliterate our rights per the 10th Amendment of the U.S. Constitution. That's the kind of stand we have to make now, because that's the world we live in now. And that's the kind of federal government that we have now. Dare I say, perhaps we've always had it that way, which is why states have been given the authority to push back in the first place, because that's the only way that you and I are ever going to live in a free republic, is when states continue to stand their ground. So that's where we are. That's what the Supreme Court had to say. Again, like I said, these are temporary stays, okay? So both the OSHA rule and the CMS rule still awaits a final judgment, okay, from the Supreme Court. We don't know when that's going to come. I don't believe there's a time limit on when that's going to come. They may let this stay just sit there for a while. The point is, we need to continue to pray and hope that they end up with the right answer at the end of the day. God bless y'all. Thank y'all.